Equal protection is guaranteed under the Fourth Amendment. It prohibits states from passing legislation that will deprive any person of life, liberty, or property without due process. Now, when we consider equal protection, equal protection means that each person is treated the same under the law. But there are some times when we allow for the government to impose legislation that does infringe upon an individual's rights. And when that legislation is introduced, we have to analyze it using the various tests for evaluating equal protection. So, strict scrutiny is the highest test. It is applied to cases of alleged discrimination when there is a suspect classification or a fundamental right involved. What that means is a suspect class is race, religion, origin, and a fundamental right are your Bill of Rights. So if the government imposes legislation that is going to infringe upon, deny, or dilute your right, then we apply the strict scrutiny test. So to deny or dilute the right, an example would be when an individual goes to take the picture for their driver's license, you have to take your hat off and your sunglasses off and show your face. However, there are some religions that require that those who practice this religion, they are to wear religious garb that covers their face and you can only see their eyes. If they want to get a driver's license, they have to take the religious garb off. That would be imposing upon their religious freedom, the right to practice, but there is a compelling government interest. So the strict scrutiny test says if we are going to interfere with a protected class or a fundamental right, protected class is religion, fundamental right is the freedom of religion under the First Amendment, then the government must have a compelling government interest. In this example, the compelling government interest would be we need to know who you are for identification purposes. And this is the least restrictive means available because we're only requiring that you do this in order to get a government issued identification card. So the strict scrutiny test. The intermediate scrutiny test is applied and the government must show that there is a substantially related important government interest when there are allegations of gender discrimination as well as another category which is illegitimacy. So if legislation is passed that says that a woman can't do something or a man can't do something, then the government has to demonstrate that it is substantially related to an important government interest. And then the lowest test is the rational basis test. The rational basis test says that it has to be reasonably related to achieving a legitimate government purpose. So there are statutes in place and regulations in place that say a prisoner cannot receive certain types of magazines. They can't order those magazines, like porn magazines, for an example. So that is not an inmate is not a protected class. It is not a fundamental right to have that type of material. So as long as the government can articulate a legitimate government purpose, that being we do not want inmates to receive this material, which can then disrupt the function of the prison system. That is a rational basis test because, again, it takes the person outside of a suspect classification, which is going to be race, religion, origin, sex, and it also takes it out of the fundamental rights, which would be your Bill of Rights, and says this is just rationally related to our legitimate government purpose. So the reason why we have these tests is because we do have fundamental rights. Those fundamental rights are your Bill of Rights. Okay? But they are not absolute rights. Some of those rights can be infringed upon. And when it comes to infringing upon rights, there can be restrictions in what we call time and place. Um, and with that, but if there's a restriction, we always analyze which level of scrutiny are we using. And is this restriction some of content? Is it because they're a protected class? Is this a infringement upon a fundamental right? And then this is the test that we use. So now let's take that to freedom of speech. Freedom of speech is protected in the First Amendment. Freedom of speech includes freedom of expression. Okay? Now, your freedom of expression and your freedom of speech can be limited in time and place. So if you want to exercise your right to freedom of speech and expression, you want to have a rally, you can do that. But it can be limited in time and place, meaning you cannot just come into a government building and start protesting right now while the government is attempting to operate and block the egress and ingress, which means the entering and exiting of the building. Because we get your right to, and we are balancing your right to express yourself, but we also have a right to run a government office. So there has to be a balance. And what the court does is say, is there a more least restrictive way? Meaning that while we can limit time and place, we can move you to a different location, perhaps across the street, where you are still exercising your right, but you are not imposing upon the government's right to do its business. So that's your freedom of expression. Now, there are 5 categories of what we call unprotected speech. And so when we talk about protected speech, as long as it doesn't fall into one of the unprotected categories, we usually view it as protected speech. So the 5 categories of unprotected speech, the first category is obscenity. Obscenity is, in the court case is the Miller case, it says that anything that appeals to the Puritan nature, which means the sexual nature, like nude dancing. Nude dancing is considered symbolic speech, but only the dancing portion, because the court has said by taking your clothes off, you haven't added any more artistic value to the dancing. So the dancing is your expression, but taking your clothes off and being completely nude is not the expression part. So obscenity is not protected speech. So we can regulate it, which is why when people talk about having clubs that where people take their clothes off, they can regulate that. There are regulations that say you have to wear pasties or you can only be topless because the obscenity portion is not the protected speech. Now, there's a debate between obscenity and art. There was a documentary on HBO a couple of years ago now where there's an artist who gets who does like a flash mob of people who lay down in the streets and they're completely nude. He takes pictures and he sells them as art. So the art is protected, but laying down in the street is not. So if the police come, then those who are laying down in the street naked often run off because they could be arrested for indecent exposure. And so the collective coming together, taking the picture, capturing the picture is the art. The process, the court has said, is not artistic and that is not protected. If this happened in a studio, then yes, but this was in the streets of New York City and that was not protected. It was viewed as obscene and those caught were penalized. The second category of unprotected speech are fighting words. Fighting words include hate speech. The court views that as face to face, in your face, you saying something, a person has a level. Once you get to that level, then what do you expect is going to happen if you keep being antagonistic and saying mean things? Fighting words, not protected speech. Inciting or urging unlawful conduct is not protected speech. And what that means is that someone has gotten the troops together and said some things to get them fully riled up. And if we do that and I say, oh my gosh, let's charge down to the senator's office and demand that they hear us, and if they don't do it, then we have to do and take action immediately, and I get everyone and my base riled up, and then I go home and they go and tear up stuff. I can't then say, oh, I was just speaking my mind. I have the freedom to say that. The court has said no, because you did that. You incited it and you knew that this unlawful conduct was going to be the natural result. The fourth category of unprotected speech is defamation. Defamation is saying things that are not true about an individual that has, and it's purposeful. We will discuss it when we talk about torts. It is an intentional tort where you purposely say things that are false about an individual and it subsequently ruins their reputation or something in their life. There is a natural result of something negative that has happened, like I lose a job or I lose a contract. Okay? And then the fifth category is a public nuisance. Public nuisance, for an example, we regulate that. The amount of noise that a person can have. Blasting your music in the middle of the night is a public nuisance. while it is your freedom to listen to that music, I do not have to be subjected to that. So that's how we get those regulations about you have to be quiet after a certain time. Because while we are balancing your right to hear your music, we balance my right not to. And so there was in the news a couple of years ago, there was a marching band that would practice outside during the daytime while a young man who worked at night was trying to sleep. And so this went back and forth about public nuisance for some time. And they actually came out and had to measure the decibel of the noise to determine whether or not it would constitute a public nuisance. Now, symbolic speech. Symbolic speech, flag burning is symbolic speech, and the Supreme Court has ruled that that is protected symbolic speech because it is a peaceful demonstration. And while people love the flag, others do not. And what the court has said is that it is symbolic provided it is your flag, your property, you are burning your stuff. And we recognize, we may not like the conduct, but we recognize that the First Amendment gives us the ability to exercise our freedom of speech. So burning a draft card was not deemed as protected speech because the draft card did not belong to the individual. It was a government issue card, and to burn that, while it's symbolic, was a violation because it was not your property. And so, again, when we look at freedom of speech as well as freedom of expression, we go through, okay, if the law is limiting this ability for me to exercise my speech, then we have to analyze that using the strict scrutiny test. If there's a compelling government interest, then we may determine that this legislation is constitutional. Each jurisdiction is different when it comes to, in Maryland, exercising your freedom of expression, because not every jurisdiction requires that you have a permit to protest. But if they do, they can deny it based on, like I said, time and place. So we like to know where you want to protest so that we can anticipate if how much security we need to have. Police need to be notified. But as long as you are exercising and it's peaceful, we recognize that. Now, the Westboro Church, that case went all the way up to the Supreme Court and it originated in Maryland. That was individuals who belonged to the church would stand outside of funerals of the fallen war heroes and make comments, very derogatory comments, and it was considered to be fighting words. And it went to the Court of Appeals in Maryland, where the Westboro Church lost. And then when it went to the Supreme Court, they won because, again, they are, while we may find what they say repugnant, the court says that they have the right to exercise their freedom of expression, their freedom of speech. What we could do is limited in time and place, meaning not right in front of the funeral procession, but across the street. So simply because you don't like the content of the speech doesn't mean we get to restrict it unless there's no other alternative. And so pretty much most individuals agreed that the content was repugnant when they were saying things to a father who was burying his son about his son being all kind of derogatory terms. But like I said, the Supreme Court recognizes your ability to exercise your freedom of expression. We can limit it in time and place, but we cannot suppress it altogether unless there's a compelling government interest. And at that particular point, there wasn't a compelling government interest. It wasn't, while they argued it was inciting and urging unlawful conduct or fighting words, if we push them across the street, that is a least restrictive way of allowing them to exercise their freedom of expression.